It was enhanced to a third-degree felony. That was an open plea to the court.
Right out of the gate, we're diving into a forgery case. That means Mr. Ray didn't just sign someone else's name. He's accused of trying to pass off a fake financial document as real money. But here's the twist. It's not a petty charge. It's a third-degree felony in Texas. So yeah, this isn't monopoly money we're talking about.
Received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Are there any additions or corrections to the report?
Not from the judge.
All right, Mr. Rojas, you may proceed.
Thank you, Judge. Judge, Mr. Ray is here this morning asking for probation. I realize that the PSI, and he realized that the PSI, according to the PSI, this is, I believe, his sixth felony. He's only had, with those felonies, look to me like he's only had one term of probation. It was revoked back in 2000, I believe. That's the only term of probation he's ever had for the felonies. I suspect just he was in jail and probably had credit time served on the other ones. To his credit, even though he was not on probation, looks like during one of his terms in prison, he did some things to benefit himself. He successfully completed the safety program. He got his GED, and I think at one point he even he was sent to and successfully completed the IS.
You can almost feel the defense attorney trying to humanize Mr. Ray Ged, earned in prison. Completed rehab programs, caring for his elderly mom. It's the redemption arc argument. But let's be honest, will the judge buy it? Or is it too little, too late? What do you think? Do personal efforts outweigh a long rap sheet?
Program. So he does have the ability, he has shown the ability to make progress. And again, he did the safety and the GED not as a condition of probation, something he did on his own while he was in prison to better himself. He's telling me that if he were to be granted probation, he's got a job, he's going to be able to go back to his previous job as an auto mechanic. The owner of the shop has reached out to him or told him that as soon as he gets released to go back, he still has a job there with him. He is the only caretaker for his elderly mother. His father died, I think, around 5 months ago. His mother is home living alone, and he would be the only caretaker for her since the father has passed away. It looks to me like he also has a case out of Harris County that he's currently on probation for. I talked to him about that. He says he's spoken with somebody from Harris County. They're not going to revoke him. I think there was a felony that came up after that probation, but they're not going to revoke him based on that. So he still is on probation from Harris County. And according to this PSI, at least he's a low risk for revocation on the probation. So we're asking the court to consider all that and grant them a term of probation.
All right, thank you. Ms. Malfino?
Judge, based upon my review of the underlying case in which he was attempting to pass a $20,000.
Notice how the defense leans on the pre-sentence investigation report, calling him a low risk for recidivism. That's a big deal. These reports can sway sentences heavily. But prosecutors rarely let that go unchallenged, and sure enough, here comes the pushback.
$1,000 forged check, which I assume had to be some kind of connection to the person at that business for him to get his hands on that check. Based upon that and his criminal history, I just can't in good faith agree with probation being satisfactory in this case. He's continued to commit the same type of offenses after this offense, and my read of it is that he's currently on parole, not on probation. And I feel like upwards of a 5-year sentence.
It looks like I think the way I read it, he's on parole and probation.
I believe that's
for 2 felony offenses that were committed after this one was committed, and this one was committed after 3 felonies convictions. I mean, Mr. Ray, really, what Mr. Rojas said about you going to safety in the past and bettering yourself is great, and the fact that you went to ISF just in 2019, and that after that, I mean, it kind of totally just diffuses his whole argument, and he's trying to pull out anything to help you, and I appreciate he's doing that, and you should too, but all it does is point out to me that you have all the tools and you continue to break the law, and the same thing of forgeries and burglary and fraudulent use of possession. I mean, it's just stealing from people or places. And I agree with Ms. Malfino. I can't in good faith put you.
Boom. The prosecutor isn't buying it. She points out he tried to cash a $20,000 forged check, not small potatoes, and she's tying that directly to his criminal pattern. When she says she can't in good faith support probation, that's legal talk for he's done this too many times, and we're out of sympathy.
On probation. It doesn't make any sense to me whatsoever. I'm going to find that you entered your plea of guilty to forgery of a financial instrument freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of that. Sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. This was not an agreement. I'm handing you the trial court certification of your right to appeal. You do have some rights to appeal. You can talk to Mr. Rojas about that. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what...
And there it is, the judge's breaking point. This is what we call a pattern crime narrative. Repeated forgery, repeated chances, and no change. Even though Mr. Ray completed programs, the judge sees that as proof. He knows better and still reoffended. That's devastating in sentencing logic.
Devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. Good luck to you, sir. You can go back with the bailiff. All right, sir. Are you Trishad Tarrant? And this is 24 DCCR 1217. And Mr. Brewer, will your client waive the formal reading of the indictment?
We will, Your Honor.
Mr.
Cook.
Mr. Cook, I'm so sorry. There's
Mr. Brewer was the guy that's actually on duty. He's on
Gotcha.
vacation.
Thank you, Mr. Cook. And Mr. Tarrant, before we get started, I'm going to make sure that we're all on the same page. I know the clerk had you swear in, but she said that you didn't answer out loud, so I want to make sure we are all clear, that the record's clear. So the best you can, would you please raise your right hand for me? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. And it looks like in cause number 24-1217, the state has elected to proceed on the lesser included offense of the first-degree felony murder, and that's from May 21st of 2021, and how